Thank you all so very much for coming. I'm honored that so many people have turned out. It's so fun to see so many friends and family in the audience. I wasn't always going to do readings during this tour, but I decided to because I think that the subject matter might be. I think from the cover of the book, you might assume that it's a very technical book, but it's actually much more personal than I think it would lead on. And this section I'm about to read is meeting my first Innocence Project client after starting there in 2012. Interstate 45 originates in the southeast corner of Texas near the Killing Fields, a 25-acre patch of dirt outside of League City where the bodies of at least 30 victims, nearly all young women, thought to have been murdered by multiple serial killers, have been found since the 1970s. The highway runs a straight line from League City through Houston before petering out in Dallas. The featureless terrain is so flat I could almost see Huntsville 65 miles away from my rental car as I headed north out of the Houston airport. An hour later, I passed the 70-foot-tall statue of Sam Houston on the outskirts of Huntsville. A white school bus with wrought iron mesh covering darkened windows passed in the southbound lane. The Texas Department of Criminal Justice's sky blue seal stamped on its side. Prisoners on the chain, handcuffed to each other for grinding cross-state bus rides on steel benches, heading from one cage to another. 58,000 prisoners endure roughly 22,000 trips of bus therapy across Texas every year, covering close to 5 million miles. Forgotten people going to hidden places. I pulled into the visitor's parking lot and stuck the file on the passenger seat into my shoulder bag. The inch-thick stack of paper represented everything I knew about Cheney's case. There were some pages of transcripts, Jim Hale's and Homer Campbell's testimony, a copy of the appellate opinion, crime scene photos of the Sweeps' mutilated bodies, and dozens of photos of the U-shaped injury on John Sweet's forearm. Julie Lesser met me under the 3-story red brick guard tower at the front gate. Razor-wired gates parted, and we walked along a sidewalk cutting through a neatly trimmed lawn to the main entrance. At the guardhouse, a corrections officer scrutinized my New York State bar card before allowing me to sign in for a legal visit. Heavy steel doors slid closed behind us with a 1,000-year thud as Lesser and I walked the gray corridor toward a row of cubicles partitioned down the middle by thick plexiglass. Black phones were mounted on the right-hand sides of the walls. There, in the center booth, sat my first Innocence Project client. He'd been waiting a long time. During my time as a public defender in the South Bronx, I spent a lot of time visiting clients in Rikers Island, New York City, infamous island jail complex in the East River. My clients were mostly young men bursting with rage, fear, desperation, and yes, hope. In my earlier work as an appellate defender, my clients had already been convicted at trial and were just beginning to serve lengthy prison sentences, slowly emptied of hot emotions, nurturing hope for freedom in prison law libraries in upstate New York. Most of my clients, those thumbing with pent-up energy on Rikers and those warehoused in century-old upstate prisons, were deeply skeptical of public defenders. Trust was earned only through showing respect and fighting hard. Usually I lost. Often I would not see or hear from my clients again after a conviction. There was always another, more immediate crisis, another trial, another appeal, another arraignment shift. The wheel never stopped turning. There were thousands of individual people I represented, sometimes for a few minutes at arraignments, sometimes for a few years, but I had never visited anyone 25 years into a life sentence. My file also held Stephen Cheney's arrest photo, a color Polaroid from the day Detective Westfall pulled him off the construction site in Las Colinas. Deeply tanned from laboring under the Texas sun, Cheney wore a dusty white t-shirt that hugged his wiry frame. His chin pointed at the camera defiantly, exposing a prominent Adam's apple. His robust head of dirty blonde hair framed intense blue eyes. The coiled energy radiating from the photo is pure Rikers Island. And that was not the man sitting on the opposite side of the grimy plexiglass. Cheney had been drained of color. His hair and his eyes had gone iron gray. Deep lines ran like rivers across his forehead and down the sides of his mouth. His dull white prison scrubs made him nearly invisible. Only the black prison-issued Buddy Holly-style glasses stood out. I sat down on the stool in front of Cheney and picked up the phone. As he lifted his phone, Cheney bowed his head, seemingly collecting himself. When he looked back up, tears were streaming from his eyes and rushing through the lines the wind unit had carved into his face. "See," Lester said to Cheney, "I told you he would come." None of the years I had spent as a public defender prepared me for this. I never walked into a client interview and been treated like a savior, like I was wearing a cape. For the deeply religious Cheney, Julie Lesser was the vehicle Jesus had sent him, and our meeting in Huntsville was further evidence of the greatness of God. Cheney had spent the last decade watching Innocence Project lawyers free his fellow prisoners. Here was his own. In that moment, I felt an awesome responsibility. Cheney had just been a test case for me until then, an ideal vehicle for using the junk science writ to challenge the status quo. I did not think about whether he was guilty or innocent. It was simply a perfect case. But now I had a client who believed I could make prison doors open with a wave of a wand. It was terrifying. There was little I could tell Cheney about bite mark evidence that he didn't already know. At his elbow was a battered copy of Scientific Evidence, a comprehensive treatise on forensics edited by some of the most respected science and law scholars in the country. Cheney knew it better than I did. He knew about footwear evidence, presumptive blood tests, and polygraphs, the throw-in junk science used against him. Cheney knew subtle lies and liars. He knew waiting in line, but unlike me, he knew he was innocent. And unlike me, he had faith. I tried to temper expectations. There were a lot of bad facts, no more DNA to test, but Cheney never stopped smiling during the hour or so we spent together. He knew our meeting was a manifestation of his faith. God bless you, Mr. Fabricant. I wasn't sure what to say. We pressed our hands together through the glass and I flew back to New York.
Thank you. That was excellent. So without knowing that that was the section that Chris was going to read, I actually had a couple of questions about Mr. Cheney's case. And it seemed to me that with so many good reasons and such a long history, but good reasons to distrust any system. And even though you're a defense attorney, you're part of that system. So I thought it was really profound that Mr. Cheney put his faith in you so immediately. And I wonder if that's a common experience for you with these clients, or if there are other situations where there's, sort of a combination of earning trust and managing expectations that you talked about with Mr. Cheney.
One thing I should say is that every client is different, and every client is, handling their unjust and imprisonment differently. What I think is, when you get an Innocence Project lawyer, you really won the lottery. And that there are 2.3 million people incarcerated in this country right now today. And if you think of, maybe 1% of them are innocent, we're talking about tens of thousands of people, many of whom have been put there through bad lawyering or bad science or, corrupt police officers and prosecutors. So they're deeply distrustful of everything about the justice system. But my experience has been as an Innocence Project lawyer is that people understand that they've won the lottery. And they really have, because, they're 1 in a million. We only have, a tiny amount of lawyers, and we have a line of people waiting for our help that's, thousands of people long.
Okay, I wasn't going to go to this question, but now this raises, I'm a policy person, and so it seems like the solution can't be to individually tackle each of these cases through appeals because of the volume of people who are unjustly incarcerated. And so, in addition to identifying good cases to take to try to change precedent and change law through the courts, are there policy approaches that the Innocence Project uses to get at these same issues?
Yeah, one of the things that has been clear to me through the work, and that I make clear in the book, is that you really can't cross-examine your way out of a junk science conviction. And what's astonishing in this country today is that for toothpaste, for aspirin, for any other kind of consumer products that are unleashed on the public, those are tested, scientifically tested for public health reasons before they're introduced to the market. There's nothing like that in forensics. Nothing that prevents junk science from being used to condemn somebody to death for a life sentence. No scientific evidence, there's no requirement that scientific validation be demonstrated clinically or in a laboratory before it's used in the criminal justice system. The only thing standing between a junk science conviction and a jury is a judge. And judges, they don't make these decisions based on science. There's widespread scientific literacy around the country, and
and lawyers are certainly no exception. Perhaps more so, perhaps, right? But they can't be, because now forensic sciences are used more and more and more, and there's no agency that's in charge of testing this before it's used. So at the Innocence Project, we do advocate for the federal government, something like the National Institute of Standards and Technology, to do validation research before these techniques are actually used, because when decisions are made, and this is true with throughout the law, but it's certainly true in criminal justice, is that the decisions are made not about systemic issues. They're made about the criminal defendant sitting on trial in that moment, and 9 times out of 10, everybody in the courtroom believes the defendant is guilty, and are very, very reluctant to take away a tool that is useful to convict somebody that they feel committed a crime. And when I was tracing like their roots, which I do a lot of like these different techniques in the book, I was looking at how it first got into court, and how these cases came to be, and how these people who had no background in scientists became world-renowned scientists and world-renowned forensic experts. And what you see is, they have like invented their own credentials. They've invented their own board certified. Don't believe anybody when they say they're board certified. Look up what it means to be board certified, right? Often you just like fill out a form and pay your money, right? And that's it, right? So they're not doing testing, and they're not like vetting their members any longer or any more than their ability to pay dues. So then you see this first case, the first bite mark case, and the logic of that, the rationale anyway for admitting it, was used to try to convict this person who seems guilty. I talk about the case, I'm not arguing he's innocent, but that one case gets published, and it was like a virus unleashed in the criminal legal system that was cited by every state Supreme Court that introduced bite mark evidence. And then we get to Ted Bundy. It was like the germinal case as far as like this stuff goes, because it's a nationally televised trial, the first in our country. And it became a national sensation because, what was astonishing when I was actually researching the Bundy case was that they had really no evidence. Again, I'm not suggesting he's guilty. Like broken clocks are right twice a day, right? But is that they didn't have any eyewitnesses, they didn't have any confessions, they didn't have any other forensic evidence. All that they had was this bite mark. The one person who made an identification, Nina Neri, had identified somebody else under hypnosis, and then they arrested Bundy, and they're like, "Is this the guy?" "Oh yeah, this guy, right?" And so then they used the bite marks, and they became celebrities, and never looked back. And I write in the book about 2012, a hearing that we did, and they're still talking about Ted Bundy.
I was excited that Ted Bundy was in that book.
Right?
I was surprised.
All chaptered about it.
Yes, I didn't expect a Bundy appearance in the book.
Right, it's a new genre. It's untrue crime.
So, talking about these sort of self-made experts who fabricate their own credential, Mr. West, Dr. West, is one of the most colorful characters in the book. But I don't even think the book does justice to the color that he brings. And you kind of have a personal history with that particular criminal odontologist, I think is what they call
Forensic
themselves.
odontologist, right?
Can you tell the group a little bit about Dr. West?
Sure. Dr. West is probably the purest manifestation of the disease of junk science, right? And when I had started at the Innocence Project in 2012, he had already been discredited. He'd had 2 terrible murders of little babies that he had wrongfully convicted on his testimony, 2 innocent black men that were sent to death row. And he was still practicing. And we were trying to find all bite mark cases, and Eddie Lee Howard in Mississippi was on death row, another one of Dr. West's victims, and there was no DNA evidence in the case. And so I was brought in because I was becoming an expert in bite marks, which my colleague Dana used to say it was like being an expert in Bigfoot. But there's still a lot of literature, right? If you read all the Bigfoot literature, there's a lot to know. So so we had, dozens of cases, and I write about 3 of them, and, so I felt like, it became kind of my job to try to remove bite mark evidence from the criminal justice system, and as a result, I kind of felt like it was an inevitable confrontation that I was going to have with Dr. West, right? So if you're going to have to go to the mountain, right? You know what I mean? And I had said once before that I felt like, you know, Luke was going to have to confront Vader at some point, right? And it's just like, so what happened is, and he was very like, as a nihilist and really a bizarre character and an old racist that would kind of like pluck Confederate history out of nowhere and introduce it through his testimony. And he was an sexy, very, very popular with Southern juries. And he would testify in this way that would just be, you know, it was very charming, it was witty, it was funny, it was very, very slick, but totally nuts. And I had to go do a deposition with him in the middle of nowhere, Mississippi. And it was really the most terrified I've ever been in any setting, including, you know, major capital trials, because you just never knew what he was going to say, and Eddie Lee Howard's life was at issue. And this is going to be the only time I was going to get him on the record under oath to talk about, I was going to confront him with the fact that all these bite marks that he claimed to find on the victim's body, gone back and we got all the records from the original autopsy that he had never been confronted with. And when we go through these, I could see that this victim had been thoroughly autopsied, had all of her internal organs removed, had her brain removed, had been buried unembalmed for 4 days before they disinterred this body because they decided that Eddie Lee Howard was guilty, even though they had no evidence. And then they're going to find bite marks on it, even though I had no record of any bite marks in the autopsy or any photos in the autopsy or any way that you would have any notion that there were any bite marks on this victim. They said they were going to find it. And so that evidence, the fact that the victim had been autopsied and that the skin had been totally removed from the body before that they found these alleged bite marks, he'd never been confronted with this. So I knew I was going to have to go and confront him with this. And I had seen him around, you know, I mean, not in person. And then we get to the parking lot, and it was like seeing Snuffleupagus, you know, I mean, I was just like, oh my God, there he is, right? He's like smoking in his car, and it was like this lumbering guy comes into, we do the deposition, and immediately goes off the rails. And he started calling me an asswipe, you know, at one point, you know, I mean, and really, like, and we'd gone through this where he's eyeing the court reporter, and he's belching, and he's eating like crazy, and it's just like this, like, and he hadn't read anything, he'd done no preparation, he had done, you know, he was just, you know, it was a death penalty case, you know, I mean, and I had to nail him down, you know, I mean, and finally I just accused him of a fraud. You know what I mean? Which is, and he's like, my name's not Fabricant, yours is, right? That was his best line. You know?
It's a super insane deposition transcript. It was covered in some law blogs, and the Washington Post covered it because it was like the most hostile and aggressive thing. And I was like, that's my brother. But also, if you want to see footage of Dr. West, it's in the Innocence Files episode about this. So it's worth watching. He's totally insane. But
he's interviewed on a toilet seat appropriately.
Yeah, it's a crazy character. So one of the things that comes to mind when you're telling that story, though, is that this is really harsh material. So there's the loss and injustice for these men, and a terrible crime has also happened. And to stay focused on your role of disconnecting the emotions around the crime from the facts in the law that exonerate your client must be challenging. And even the way you can talk about some of these details is a little startling to me because these are such serious crimes. Was that a process for you over the years in your work at the Innocence Project and before?
That's funny, I've never been asked that. My kids are here, they would tell you that Francesca, that I didn't mention the last time, like I cut my finger a couple of summers ago and looked down and saw blood and fainted and had to be taken to the hospital.
So you're not like the obvious candidate.
No, I'm not.
Nearly died.
So I get very, very squirmy and very squeamish and squirmy. But somehow, like, I have
ability to clinically detach from it, and it doesn't bother me. You know what I mean? I've been to the body farm in Knoxville, Tennessee.
Just tell people what that is.
Right. So this is, if you wonder, how research is done on cadavers, or where your bodies end up, for those of you who are going to donate them to science, a lot of them end up in the body farm in Knoxville, Tennessee, and it's a research center, but they're studying decomposing bodies as they would how you would find them, right? So you go to, it's near the University of Tennessee, Knoxville, and they have kind of a forest area, and then they also have kind of a structure that's much cleaner and scientific-y, right? And they have also like kind of a car that's in the side of the building, so they can study bodies that are decomposing in cars. And then out in the forest, you walk through. You got to put like booties on and this kind of thing, and walk through there past the forest, and you'll see dead bodies. Some pretty fresh, with flies, and some pretty decomposed. And they're doing research on this, and I'm going to be there in a couple months to do some on cadaver dogs.
It's an unusual job.
It's an unusual job,
Yes.
for sure.
So turning to sort of a little more of the emotional fallout from a wrongful conviction. Again, Mr. Cheney, who you talked about in your reading, if you haven't read the book, this is a slight spoiler, but his alibi involved a lot of people in his life, including his girlfriend at the time. And she stuck with him through the wrongful conviction and the entire wrongful incarceration. They got married after he was convicted. And I wonder about that. That seemed, I can see why she understood that he was innocent because she was with him. But I wonder how common that is for folks, or it seems to me that the period of incarceration has so many other consequences, economic consequences, but also these relationships and people with children, or their parents pass away while they're incarcerated. And I just wondered if Steve and Lenora are a typical situation in your experience.
No, actually, they're not that typical. Parents, moms in particular, they tend to stick with their kids. But Lenora Cheney stuck with him for nearly 30 years of wrongful conviction, and she was, it's amazing. Stephen Cheney's case was the one that I was able to track the most, because there was a lot of litigation and a lot of effort to free him before I was involved, and I also got to spend a lot of time with him, interviewing him about what the struggle had been like before we met, before the passage that I read. And I got to know Lenora a little bit, and the day that he got out of prison, their car broke down on the way home, and finally, and I read about it, it was like that he was there to fix it, right? And she'd been waiting for him to be able to fix the car, for 30 years, and then he was back out, banging nails in as an iron worker, a week later, totally destitute, and he had a child that had died while he was away. He had a child died right after he'd gotten released, and so did she. One of the children was one of his alibi witnesses. So they had been just kind of devastated by all of it. And then I tell a story about Keith Harward, and that's the story that begins the book, and it's a really an outrageous crime that was committed. And a murder of a husband and a sexual torture of his wife over the course of 3 hours while their children were sleeping upstairs. And Keith Harward was a Navy sailor at the time, and they thought that this crime had been committed by a Navy sailor. And really, there was no evidence pointing to him at all. He got arrested for some unrelated crime, which was dismissed, and he had no prior record. But the allegation was that he bit this person, so he became a biter. He was in the Navy, and he was good for it. And so they brought in the dentist, and they all matched him to the bite mark. And he'd never been in real trouble in his life. His family was supportive. They'd come to the jury trial, and then he was twice convicted capitally. He was almost sentenced to death. His parents got on the stand and begged for his life. But we talk about where clients who get put away for 20, 30, 40 years, life moves on. People move on. People get remarried. Usually they'll divorce their incarcerated husband. parents die, they're often like can't go to the funerals. That happened to Keith Harward too. And and his brothers had attended this trial, and I write about a scene where we were waiting for him to be released, and I was talking to his brother, and his brother was telling me that when he'd gone to the trial, that he'd always believed in his brother's innocence, but that he watched the testimony of the forensic odontologist, the expert witnesses, and he began to doubt his own brother's guilt. It was that persuasive. He was looking at it and he was saying that, what are my little brother's teeth doing on that woman's thighs, right? There are pictures of the injuries that we're talking about in the book. And it was that powerful. It was junk science, like, to make your own brother, forget, to sow doubt, and then when he was, reunited with them, he hadn't seen them for 30 years, and it was just really, it was a very powerful moment. It was devastating.
I'm going to ask one more question, and then we're going to take some questions from any of you who have them. I know we have lawyers, we have scientists, we have people who have brothers here in the group, so consider your questions. But some of the wrongfully convicted have been able to secure compensation from the state for the wrongful conviction. And I looked up Minnesota's statute today, and you're entitled to up to $100,000 a year in Minnesota for every $100,000 for each year of wrongful conviction. And I just wondered too about your experience with that it seems to me that the financial compensation is essential because they are, as you said, impoverished typically, and it's also not enough. So I just wondered if you could comment on that and how it plays out differently in different states.
Yeah, there are many states where there's no compensation, and if you are familiar with what's called qualified immunity, this is where police and prosecutors basically can't be sued for misconduct. So, a lawsuit, everybody thinks, I'm going to get out, I'm going to sue them all, right? But it's very, very, very hard to win those lawsuits, even though you've been slam dunk innocence, obviously wrongful conviction. Every state is a little bit different. Often they have, inhumane caps at maybe 100,000 for, the whole thing, right? You've been in for 30 years. And in Texas, like in Stephen Chaney's case, nobody can get compensation unless the Texas Court of Criminal Appeals, there are two state Supreme Courts, right? There's one for criminal matters, one for civil matters. And that court, which is, it's exactly the kind of court that you would expect it to be in Texas, and you have to be declared actually innocent. This court has to find you actually innocent of this crime before you're entitled to compensation, which is almost an impossible hurdle to get. And it's always shocking to me because there's these fights in the legislature. No, we can not too much money, or we're not going to do that. This whole thing is just like, how many people are we really talking about? And it relates to the budget. Are you really going to prove innocent that you're not going to compensate for destroying somebody's life? For wiping out their entire. It's astonishing. It's some of the lack of compassion that I kind of expected that when I was a public defender, because people have their views on law and order issues. But when you're talking about innocence, I've been astonished by, how many adversaries that we have and the reluctance to really do the right thing, even when they know, that the truth has finally come out.
And the unwillingness to admit for prosecutors to, even when there's proof, DNA proof sometimes that it was a different offender.
Right, we talk about it in the book, the unindicted co-ejaculator theories that we get. Right? I didn't make that term up, right?
New York Times article.
Right. And so what it is that you'll get, and I talk about one of them, Michael West. He had his own unindicted co-ejaculator theory, that he let in. So you just have these bizarre explanations to explain away really probative DNA evidence. Like one of the ones I write about in the book was Anita Alvarez, who's the Attorney General in Illinois, or Cook County. And there was 5 young kids had falsely confessed to the rape and murder of a woman, and were all sentenced to life in prison. And when they finally got the DNA and they tested the DNA, it came back to one source, and it was a serial rapist, and who I think also confessed at some point, so it was plainly this guy, right? And so she advanced a theory that, a necrophilia theory, and that the boys had raped the victim, and then this person had come along and then raped the body, right? Yeah.
Unwilling to accept the truth.
Right,
even
and then
after
she
all
was like, so that was, she said that on 60 Minutes. Right, so people get very dug into, their convictions.
Yes. Does anyone in the audience have a question?
Cheney, clearly spiritual. Is that common or is that highly unusual?
Yeah,
Kind of finish your story. If you can't-
Yes, it is fairly common for clients to, people need some sort of solace, and something to hold on to. But not everybody, Keith Harward is not religious, but Stephen Cheney certainly was, and a lot of, what's really sad, and sometimes you see this now, is that you'll have people that, have only spent maybe 10 years in prison or something like that before we get to their cases. And unlike with Stephen Cheney, you could see all this work that he had done since he'd been in prison, that he had gotten all these certificates of achievement, and he'd learned engine repair and diesel repair and all these studies, and had gotten an associate's degree, and had never been violated for a slightest infraction the entire time that he was in. But then it all stops, about 10 years before we get there, because all these prison programs have been eliminated around the country. So you can't even demonstrate, that you're, trying to, improve, even assuming you're guilty, or you're innocent, that you don't really have any way to be constructive with the time that you're being required to serve, right? And this creates reentry problems, and that we're just warehousing people.
Also, we'll get to you, sir, in just 1 second, but just to connect this to that, despite being a model prisoner, you often can't get parole if you won't admit your guilt. And he did not want to admit his guilt to something he didn't do. But then also sometimes, even when a sentence is vacated, the prosecutors say, well, we'll let you go with time served if you admit your guilt. But if you admit your guilt, you'll never be found actually innocent in order to get the compensation to which you're due. I will say, Minnesota law, you don't have to be found actually innocent. It just has to be evidence consistent with innocence, because we are a superior state to Texas. All right, sir, in the head.
Do you have any impression as to the presentation of evidence in a court setting where there's like cameras? Like, I'm thinking with the Cheney thing, the performance, if you will, of some of the people who presented. How do you think that will affect stuff?
You mean the theater of court?
Yes, because that's obviously a big piece of it.
Yeah.
And I think science in particular is very susceptible to that when you're an expert testifying.
Yeah, well, most trial lawyers will tell you that, courtroom, and trials, they're as much theater as anything else, right? A lot of trained actors go into trial work, and we are often trained in our trainings by actors, to teach us how to convey emotion, how to use our bodies, how to be persuasive, right? That's our jobs. And expert witnesses have similar training. They have moot court trainings. They practice getting cross-examination. They want to be persuasive. They want to be, good witnesses for the people that hire them. And what happens in criminal courts and in courts all around the country, because most science, good science, will admit all the limitations to the technique, right? Whatever the thresholds are, what they can say or not say about it. Research studies will show, well, it didn't answer X, Y, and Z questions. Normal part of science. But lawyers, when you get into court, are going to take these concessions and they're going to drive trucks through them, right? Because that's the lawyer's job, is to pick them apart, and so you get bad science or good science can be twisted in the criminal setting, in a trial setting, because once you go to trial, the gloves are off, and both sides want to win, and they're going to take every tool that they have to win. And this is what I was talking about earlier, is that we need upstream fixes, right? That's not the place to sort out the sense from the nonsense in criminal trials. Because what's happening in there is not it's not real, often.
Yes. What's the instance where, so we've got lawyers, sometimes many lawyers, presenting to judge and jury, and it's the jury that makes the decision, and they may or may not have any knowledge about science or what's at hand. And do you ever think that the judges are just like, oh, they got it so wrong? But the judge can't do anything about it. Is that common?
Well, I mean, the judges are responsible for allowing the evidence in to begin with, right? So I don't think that they're often thinking that they got it so wrong, unless they do an acquittal. I think often they bemoan an acquittal. It goes back to what I was talking about earlier about scientific illiteracy. You know what I mean? Is that, I shudder to think, like earlier in my career, so many of these techniques that I didn't challenge, right? I believed it like everybody else, right? Oh, it's scientific evidence. You get confronted with it back when I was a baby public defender. And I would do one of two things. I'd go looking for a plea, or I'd be changing my trial theory to account for this new evidence. And, then we have, something I write a little bit about in the book is what's called the CSI effect, right? And all of you have seen shows like Forensic Files and CSI and Quincy for the older crowd. I grew up with Quincy, right? It's like all of that. And forensics are depicted as infallible in those, right? And conclusive and objective. And this is a fact that you can hang your hat on, that you don't have to worry about is being shaded by a biased expert or a biased witness, or somebody who's got an axe to grind, or somebody who was drunk when they observed it. It's really powerful stuff. And those shows are really doing a lot of damage. It's part of the reason I wrote the book, was to try to, unpack some of the fallacies that are around this through good stories, right? Because that's all we really want to hear is good stories. Nobody wants to read science, but for the most part, right? It's like with notable exceptions. One of the cases that we will sometimes take cases that we see on Forensic Files, right? And we'll look at these cases that are depicted. Alfred Swinton is a great example. Is that we watch the Forensic Files episode and see him being depicted as a serial killer. They tried to put 8 bodies on him, but he's only convicted of 1, and he was used a bite mark. It's like the only evidence against him. So we took his case, and 16 months later, he was exonerated completely. 5 years later, you could still watch the episode on YouTube showing him as a serial killer. And that is like, and thank God for the bite mark evidence, right? So it's really, again, why you can't let it into court to begin with. So I think the judges, to the extent they're thinking about it at all, they're only thinking about like everybody, the jurors, everybody. Did they get it right? Right? Did they convict the right guy? That's, and like the idea of like what was used to convict him is way down on the list of considerations.
Okay. Let's see. I took it avoid relatives for just 1 second. Lady in the purple sweater.
When you said earlier that that this stuff can just come in easily, I'm not an attorney and I don't pretend to be, but there's Fry, there's Dover, right? So how does this stuff get past those?
That's a great question. The question was that there are, I don't know your name, so I'm just going to say she, pointed to, there are 2 major tests for the introduction of scientific evidence in the criminal, or both systems, civil and criminal. One is called Fry, and one is, and I'm going to use Daubert, even though I know it looks like it should be Daubert. I know people who know the Dauberts, and that's the way they pronounce it, right? So I devote a chapter on this to the book, because in the 70s, there was an explosion. The whole legal system just expanded exponentially, both through mass incarceration on the criminal side, and on the civil side through mass tort litigation and product liability and personal injury litigation, which hadn't been, like in the earlier part of the 20th century, it wasn't as prominent. And it created whole cottage industries of expert witnesses. People became professional witnesses, which hadn't been an industry before. Same way that forensic science had not been an industry before. So corporate America was getting sued like crazy all the time, right? Dalcon Shield, and it's like Ford Pinto. Some of it was righteous litigation, and some of it was a lot of garbage that was based on a lot of junk science. And so corporate America teed up the Daubert case to get it to the Supreme Court to see if we could get a new test that required judges to exclude evidence that was unreliable. The Fry test, what they were supposed to do is defer to the scientific community, the relevant scientific community, and say, if those scientists buy it, then it's good enough for the court. Problem is, the courts always define the relevant community as the people that were making their living doing that technique, right? So the same people who invented their credentials, they were asking those people, is your science generally accepted, right? Your answer is obvious under that, right? So then Daubert came along,
And they radically changed the way the courts are supposed to be analyzing this evidence. They were going through this list of factors that you apply to a forensic technique or a scientific technique of any kind to see whether or not it passed scientific muster. So I did a research study that is part of like the basis of what I wrote with a professor named Brandon Garrett, and so did my boss, Peter Neufeld, in the 90s. I did a follow-up study a few years ago, and what it shows is that on the civil side, the Daubert case was really good at excluding a lot of unreliable evidence. On the criminal side, nothing changed at all. And that the prosecutors got in whatever they wanted, and the defense could never exclude anything. You know, and there's an empirical basis for that, and it relates to a theme that I talk about in the book called poor people science. And what it speaks to is our values as a society, right? Is that we care more about money than we do about life and liberty. And it has to do a lot with the black and brown people that are primarily prosecuted or overrepresented in the criminal legal system, and this effort that it's about social control, and it's not about getting it right. And it's not about caring about what kind of evidence, the quality of the evidence that's used in the criminal justice system.
Okay. Yes, nicely said. Uncle Dan.
Chris, so you're a very successful baby defender. And then one day you say, you know what, I want to do something else. What was it? What was the aha moment that you had?
When I didn't get that tenure track job. No, I mean, anybody, most lawyers, I had the best job in the criminal justice system without question. I love it, and, whenever we have a job opening, we get a tidal wave of resumes, every lawyer, I was talking to some before we started tonight, when you go to law school, you're very idealistic and you want to help people and change the world, and I'm not claiming to have changed the world, certainly, but I've certainly helped some people, and, that's the best feeling. It's the greatest work that you can possibly do. I felt that way when I was a public defender. Seriously, so that's the most righteous work that there is, and working at the Innocence Project is no more righteous. It's just that much more powerful, and what we have and the approaches that we take to litigation is much more systemic, and my role is really to try to change the law, and I think most of us who have done this work for a long time, like what Joelle does, is an effort to really move mountains, rather than just individuals, so that's the aha, I guess.
So you actually kind of started to answer my question with that, but I was surprised when you first started reading, so not a lawyer, when you started reading about, like, and maybe I'm misquoting, but like that his guilt or innocence wasn't important to you.
Right.
It was, so I guess I was just kind of surprised by that, given the nature of
Innocence
the
Project.
Innocence Project. Right, and you think it'd be like, I'm passionate about this person being innocent, that's why I'm here, but it sounds like it's more like this, like it's an opportunity to test a theory that will help more people in the long run. So
Yeah.
I guess, can you just talk about that a little bit?
Yeah, so a lot of the work that I do is to prevent wrongful conviction, is to try to eliminate the leading contributing factors to wrongful conviction. And so that's eyewitness misidentification, it's junk science, it's false confessions. And one of the themes that I explore in some of the court cases or client cases that I talk about is when you don't have DNA evidence, is that you're never going to know ground truth. And you have people like Stephen Chaney who, I believe in my soul is innocent, but that's not a scientific fact. We can't know that. We can never know that. And that is really, why it's so difficult to overturn these convictions. So when I saw, and then we put out, I was litigating cases before they went to trial to Fry and Daubert hearings to try to prevent junk science from entering in the first instance, because we know that the search for the truth is never advanced through the use of junk science. And so when I learned about Stephen Chaney's case and that a witness had testified that there was a 1 in a million chance that anybody other than Stephen Chaney could have made that bite mark. And there was a new law in Texas that became known as the junk science writ. And it was really for that type of case where we need a path back into court to be able to litigate these cases when you can demonstrate that evidence that was used and called scientific at trial has been discredited by progress of science.
And so we were trying to eliminate the use of bite mark evidence, and that we could do that if we could free Stephen Chaney and get his conviction overturned using this new statute, then it would also, in fact, the way that it would be treated coming into court to begin with, right? And so the idea is that we could free this innocent person, somebody I believed ultimately came to believe and understand was innocent, but at that time, either way, he'd also done 30 years, and that's a lot of time, right? But the idea was both, really.
So, just a quick follow-up. So, if you believe they were guilty, would it matter?
Really depend on all of the different, in death penalty litigation, often, what I will try to do is, because of what I said earlier about, junk science not advancing our search for the truth, is that we look to, if somebody seems like plainly guilty, and we've had, and I'm going to return to that in 1 second about plainly guilty, because that's very, very rare, but it's going to be a very challenging, almost impossible case to litigate anyway. So it's the closer cases that, we're going to take to begin with. But one of the really important lessons that the Innocence Project has taught the world, really, was through the intake criteria when it began. And the intake criteria was like, you could have 20 eyewitnesses said that's the guy, right? You could have a confession, you could have all kinds of other evidence. But the theory was that if you could find biological evidence and test it, if that were to prove innocence, if that came out that DNA was not his or hers or attached to somebody else, that's the only criterion. So they took cases where there were lots of eyewitnesses, there were confessions, there was other forensic evidence that was used, and those people were exonerated. And it showed how fallible some of the main planks that we're using to convict people are. And so, we should all suspend our judgment about what we really know. If it's not nuclear DNA analysis, then really you should be skeptical.
Yes.
What is the new junk science that you're seeing and you're concerned about?
Oh my gosh, there's a lot. There's some new technology that I'm particularly concerned about is ShotSpotter, and ShotSpotter is these tiny microphones that they put mostly in marginalized communities, and what they'll do is claim the ability to detect gunshots, and separate them from things like backfires from cars or other loud noises, and to direct police resources to those areas. So superficially, it sounds like a reasonable, thing to do. But what happens with this technology is that, and it's not designed for, is that they're trying to enter it into court as evidence in actual cases to show that it's an automatic weapon rather than which would be greatly enhance somebody's sentence. Or I had a case where there was like a alleged shootout, so they were trying to show that there were two guns being used. One was the cop's gun and one was the robber's gun, right? So that's not what it was designed for. And so that type of evidence creeps into court, and what they don't say is actually it's not some fancy computer algorithm that's ultimately making the decision. It's a human being that's making a decision, and that can be a biased decision too. There's also something that I'm particularly outraged by, and I went out and I did a Doward hearing in Colorado like 2 years ago now. Cadaver dogs, right? So the theory on cadaver dogs is, hang with me here, right? It's like they have a dead human body in a probative area for some reason, or that the prosecutor's theory there was a body in this spot for whatever reason. But there's no biological evidence, there's nothing else to show. There's no, they're just a theory that a body was there. And so you get these dogs that are allegedly trained to detect residual odor of human beings, volatile organic compounds that all organic material emits, that decompose, and that even when there's no trace of body left, even years later, that a dog will come, will bark at the spot and say that that's evidence that a dead human, not a dying human, not a dying dog, not a hamburger, not a bloody nose, right, that a dead human being was in that spot. In the case that I did in Colorado, they had a dog that got this, the prosecution theory was that there's a body in the bed of a pickup truck in Durango, Colorado, in the mountains of Durango, Colorado, for 2 years, outdoors, through all seasons. Dog gets up, barks in the pickup truck, and that was introduced as direct evidence of guilt. After we had litigated the Doward hearing, and the judge had allowed it in. And when I was watching the actual trial, because we just did the pre-trial, when I was watching the actual trial on YouTube, you could see the comments from the audience, the online audience, totally credulous. believed it all. Thought that the expert witness for the defense was a total idiot. Didn't know what he's talking about. We all know dogs have their noses are a million times like strong. You know what I mean? It's just like so. This is why you seem persuaded that it's junk, but it was he's got convicted. It's really the only direct evidence. So I could regale you with more. We can talk later.
I just want to say too that, and this is kind of to Matt's point, that part of the judge's job is to keep bad evidence out, but also the prosecutors have a responsibility to disclose the whole picture. And so what the jury sees is never the whole picture. And there's a lot in the book and a lot in Chris's stories from his whole career about bad behavior by prosecutors. So in some of the bite marks, for example, the first pass at it, the experts exclude a particular suspect. And then later, when the suspect has already been identified, those same experts come back and say, well, now I think it's a 1 in a million match. But the defense is entitled under law to know all of that, and they don't tell them. And so the stories, you can read in the book, the first pass of the evidence, a story can be told that sounds very guilty. And then you can get the full picture and you realize you can't be so sure. And that's an extension of the systemic dysfunction in the criminal justice system is the prosecutorial behavior in these cases.
Yeah, it really is, and it also just shows the power of junk science too. What's great about junk science is that it can say whatever you need it to say, right? That's why it's being used.
Chris, we now have a law group in Minneapolis that sues the city and gets great recoveries on police misconduct. And I'm kind of back where Joelle said, how can we do a policy deal? Isn't there a group of wealthy tort personal injury lawyers who would like to partner with the Innocence Project on a case and really put the fear of the Lord in the other side? Have you tried to explore that? Or is it just impossible?
Well, the Lowy in Chicago is a big law firm. That's their motto, is that they do both. And so, it's one of the things that concerns me about that approach is that you get people that are going to be even more dug in on the convictions and all the less willing to overturn them if they're worried about civil liability. And so that I think is, I would rather free the innocent and worry about civil liability later. But, another part of what your question is, and you'll see in the acknowledgments at the end, the people that none of my friends know are the pro bono partners that I've worked with major law firms that have helped on this type of litigation, because I have a small team and we have, huge impact with relatively few people, and that's because we work with a lot of pro bono partners. But yeah.
From a public policy standpoint, what solutions do you think we as a society ought to be looking at? I mean, ideally it should happen at a national level, but it's so hard for Congress to do anything. So do we end up with just individual states trying to, form a commission to look at this and prohibit certain things? Or what are your thoughts about that?
That's a great question. I spend a fair amount of time talking about the Texas Forensic Science Commission, which is very important to Stephen Chaney's case, and it's the leading forensic science commission in the country. And, paradoxically, Texas is actually pretty good on science. That was where the junk science writ was, and that's where the Texas Forensic Science Commission was formed. And that's because they've had wrongful executions in Texas based on junk science, right? I write about 4 of them in the book. So, but what they do is, and it's important for it to be a blame-free environment. They're not a regulatory agency, and they can take a case or a technique, and they will invite experts from all the sides to debate the science. There'll be transcripts, and then they issue reports, and it's really the closest that we have to what you're talking about. And so the Innocence Project has worked with advocates around the country to get more of those types of commissions formed. And then we really need to have, real research being done. We need real dollars to be put into this research, because forensic experts, by and large, are well-intentioned people, right? They're not going out to try to convict innocent people. They want to do the right thing. They're trying to, convict guilty people. Is that there's no requirement that they have PhDs. There's not a lot of money in their training. there isn't, it's just, it goes back to, again, like, how much do we care about the people we're prosecuting? Not that much, and so yes, state court or state level advocacy, and that's true for a lot of our advocacy approaches, because the Supreme Court is going to be as currently constituted for the rest of my career in all likelihood, and we're not going to get our issues advanced in that court. So it's going to be in state high courts and other types of advocacy to really, reform, some of the major problems. I think we're getting a signal that we
I think we're
wrap up.
All right,
All right.
thanks, everybody.
Thank you so much.